Recently, 3 California municipalities, Stockton, San Bernardino, and Mammoth Lakes, filed for bankruptcy protection under Chapter 9 of the Federal Bankruptcy Code. Although these cases are in the early stages of the Chapter 9 process, the available information provides some insight on the contributing factors to these Chapter 9 filings. Stockton and San Bernardino appear to share some common factors, including long-term imbalances in revenue and expenditures, recent declines in revenues due to the economic downturn, some constraints in reducing current expenditure levels in the short term, and increasing costs to provide retiree benefits. Additionally, Stockton appears to be impacted by substantial borrowing, while prior budgeting practices such as borrowing from internal funds appear to be a factor in San Bernardino's case. In contrast to San Bernardino and Stockton, the town of Mammoth Lake's filing appears to have been caused by a single significant event, a recent legal judgment that required the town to pay a land developer an amount more than double its annual general fund budget. These filings have raised some questions about the use of Chapter 9 in California. Chapter 9 is a section of Federal Bankruptcy Code created exclusively for local governments to adjust or reduce their obligations when their resources are inadequate to cover those obligations. Chapter 9 filers are provided with protection from their creditors while they develop a plan to move toward financial stability. This plan can include reducing payments on bonds and other debts and rejecting contracts and other types of agreements. Chapter 9 cases are different than other types of bankruptcy cases in that the Federal Bankruptcy Court has limited power over the local government. First, the court cannot force the local government to file a case. Second, the court cannot force the local government to sell its assets or raise taxes in order to generate revenue to pay for its obligations. And finally, the court has no power to cause the local government to dissolve or reorganize its governance structure. Federal law allows all local governments, including counties, cities, school districts, and special districts, to file for relief under Chapter 9, provided that their state government gives them authority to do so. California gives local governments broad discretion to file for Chapter 9, but it requires them to engage in a neutral evaluation process first. The majority of other states require local governments to obtain permission from their state legislature before they can file a Chapter 9 case. Once the local government files a Chapter 9 case with the Federal Bankruptcy Court, the court's first responsibility is to determine whether the local government is eligible for relief under Chapter 9. In order to be eligible, the local government should be insolvent, that is, unable to pay its bills as they become due. It should have no feasible alternatives to bankruptcy, as bankruptcy is intended to be a method of last resort for adjusting their obligations. And finally, the local government should demonstrate intent to adjust its debts and not just be attempting to evade creditors or delay payments on its obligations. The Chapter 9 process typically involves 5 major steps. First, the local government files Chapter 9 and receives what's known as an automatic stay. The automatic stay stops collection activities by its creditors and protects it from litigation. Second, the court determines whether the local government is eligible for relief under Chapter 9. Third, the local government develops what's known as a plan of adjustment. The plan of adjustment is the primary goal of the Chapter 9 process. The local government has sole discretion over the development of the plan of adjustment, as well as what tools to adjust its obligations, such as restructuring its bonds or other debts or rejecting contractual agreements it will use to place itself on a path towards fiscal stability. The next step is for the local government to present its proposed plan of adjustment to its creditors and achieve approval from at least one class of creditors that would be negatively impacted by the plan's proposals. The final step is for the court to confirm the plan of adjustment. In deciding whether or not to confirm the plan, the court will determine whether or not the plan would require the local government to violate any state or local laws, and whether the local government has the required authority from regulatory bodies or from voters, or whether the plan would disproportionately benefit certain groups of creditors or other groups. And finally, whether or not the local government and its affected parties would be better off if they were to adopt the plan versus other situations. If the local government fails to make timely progress through these 5 steps, the court will dismiss the bankruptcy case and remove the local government's protections. The court may not approve a plan of adjustment that will require a local government to violate state or local laws, with the exception of laws pertaining to contractual obligations. This is true even if those laws would hinder the local government's ability to achieve financial stability. For instance, the court cannot authorize a local government to increase property taxes beyond constitutional limits or bypass voter requirements for raising other forms of revenue. One of the tools provided to local governments by the Chapter 9 process is the ability to reject contracts, including agreements with employee groups known as collective bargaining agreements. If a local government wants to reject a collective bargaining agreement, it should show that not rejecting the agreement would hinder its ability to achieve fiscal stability and would cause the employee group to bear a disproportionately small burden of the local government's Chapter 9 process. Additionally, the local government should show that it negotiated in good faith with the employee group and was unable to reach an agreement. A local government's agreement with retirees to provide pension or health benefits are generally considered contracts that could possibly be rejected through the Chapter 9 process. However, Chapter 9 cases dealing with retiree benefits are rare. Due to this lack of case law, it's unclear if and under what circumstances the court will allow California local governments to reduce pension or retiree health care benefits in future Chapter 9 filings. Chapter 9 can provide insolvent local governments an important means of aligning revenues and obligations to allow them to continue meeting their primary function of providing public services to their residents. On the other hand, a Chapter 9 filing can require significant sacrifices from creditors and those with whom local governments contract, such as vendors and employee groups, and it can also be a significant obligation of time and money from local governments to complete a Chapter 9 process.